Thank you very much for having me on this panel. I'm delighted to be speaking on this topic together with Rishab and Shwetha. We're going to have a rather free-ranging discussion, and with the great, I will kick off the discussion with some general remarks about the use of technology in international arbitration, and then I'll touch on with my thoughts on arbitration intelligence and the use of e-documents in particular in international arbitration. So the topic that we have is technology tools for complex disputes beyond virtual hearings. I think that's actually a very, very apt topic, because what I find most exciting about the revolution that we've been through in the last 2 years or so since the pandemic has forced technology upon us. You know, lawyers are a rather conservative profession, and we've probably been reluctant to adopt new technology if it hadn't been forced upon us. And one of the things that struck me when the pandemic forced the use of technology upon us, and in this case it was Zoom and the use of web video conferencing, is that this technology, it can allow us to just go beyond just using virtual hearings and Zoom to simulate what we would have achieved in in-person hearings and the way we're doing things before the pandemic. I think the real value in this, the use of this technology, is not to try and recreate what we had prior to the pandemic, but actually for us all to start thinking about how we can do things in new ways with the technology that we have. And one example that I began thinking about quite early on, as I got used to using Zoom in my hearings and work, was that this liberates us as international arbitration practitioners from what I call the tyranny of distance. I think I began to think that perhaps quite a bit of international arbitration procedure was designed around the fact that we were all usually in different locations in different parts of the world. And therefore, for us to meet, we would have to pre-arrange the time, we would have to travel, and it took a lot of time and cost for us to meet. But this has all changed now by the use of this sort of technology. We can meet, we can say in half an hour, let's all get together on a Zoom, and we can all be on a Zoom. And I think we can be almost as effective on this kind of platform as we're meeting in person. So the value of this, I think, is not so much to recreate what we had prior to the use of this technology, but how we can use this technology to start thinking about how we can do things differently. The idea with them would be, would we design our arbitration procedure as we had in the past, that we would essentially maybe meet once at the beginning at the first procedural meeting, and then not meet again until we have the hearing, which might be a year and a half later. And we might have designed it that way previously because it was expensive, both time-wise and cost-wise, for us to get together. But if we can meet more often and more conveniently and more efficiently and cheaply by using this platform, should we redesign the way in which we do arbitration? Should we have, one final hearing where all the issues are heard at one go? Or can we break the case up and have smaller hearings on discrete issues that make sense as it goes along the way? And there's no impediment to doing that time and cost-wise now that we adopt this kind of technology. So that's what I've been quite passionate about since being introduced to this technology because of the pandemic. And that's why I think we should all be thinking about beyond virtual hearing. Let's not think beyond how do we recreate what we had in person with this technology. Let's think about what we can do with this technology, which we couldn't do in person. And that's the exciting conversation. So let me then, we don't have much time for this session. We've only 20 minutes, and Rishab and Shwetha also are going to share their experience. So let me then briefly touch on two topics that I'll give my thoughts on. One is arbitrator intelligence. I think it's a great thing. I think it's a great platform. Like all technology, though, it would depend on the input that you get on it. And of course, we know the arbitration intelligence movement out of the US, and I know that they have a tie with SIAC, that after each SIAC arbitration, they will collect information about the arbitrators from the participants in that. I think it's a great process. I think as with all kind of technology, what's important is that the input gets in there and the database grows. And hopefully through this collaboration with SIAC and other institutions, the database for arbitrator intelligence grows. I think it will be a fantastically useful tool, because we all need, I think, more information about how arbitrators really do their work. It's in the past, I think the best you could do is word of mouth, reputation, speaking to somebody who's been before that arbitrator. But I don't think, that's can give you sometimes a partial, perhaps a blurry picture. And if you could get a clearer picture about how arbitrators really perform, I think it really helps the whole process. And I think it's also important for widening the scope of the field of arbitrators. If we have more information about how arbitrators perform, then parties may be more willing to use someone they haven't used before, rather than defaulting to the usual names that they've seen. This is, he's appeared before, he's been written about before, and we go to him because we think, well, he's a known quantity. What arbitrator intelligence will help with, I think, is that more arbitrators become known quantities. The other thing I said I would talk about is document management in e-document. I'm a great believer in technology. I think I'm quite savvy technology-wise, and certainly all my reading now has mostly moved on to the electronic platform. I used Kindle and Apple Books, and even all my research and stuff, it's all done on screen now. I hardly pull out a book to do anything with that. But the one thing which I find that still technology hasn't come up to scratch yet with regard to e-documents is hearing bundles and using that effectively, completely without paper for a hearing. I've done it before when I've been forced to, because especially with emergency arbitrator hearings and things like that in the middle of a pandemic, I can't ask parties to send me paper when I know that they're not supposed to be in the office. So I've worked in it with multiple screens, 3 or 4 screens, several iPads, multiple screens open. It can work, but I find still that there's still a gap in technology, that it's not so easy to flip within documents. I think it just that little processing, at least in my case, the way that my mind was, that little bit of processing power I need to switch from this document to that document and look for that tab and this tab, slows me down a little bit. And I'm much faster if I've got bundles before me. I've arranged those bundles and I can reach out for that. I think that's the thing about e-documents right now. So I recently, in January, I had a 2-week hearing in that case, I happened to be counsel rather than arbitrator. And we had all the latest technology. Obviously, it was on Zoom. We used one of the providers for this. It was on Zoom. And we used their e-document technology. And it was great. I think it helped in certain ways, because when you were referring to a document, they can quickly pull it out on screen. You can all see the document. And that saves time. And it works particularly, I think, in this kind of virtual format, because you're staring at a screen anyway. So when they put the document out on the screen, you're looking at the screen anyway. If it was in person, it may be a bit distracting, because you have to turn your eyes away from the tribunal, perhaps, and look at a screen. But on this context, it's great. The only thing, though, is as counsel, I wouldn't give up. You just rely on that on my own if I have to present. And I still had next to me a whole bunch of documents on my table, because I just didn't think I could switch to the documents I needed to refer to quick enough. I would love it if that could happen. I would absolutely love it, because I said all my reading anyway now is on screen. When I'm getting up for the case, I'm looking at the documents on screen. It's just that I think what's a little bit of a gap, and what I would love to see filled, is a way in which we can manage masses of these documents in as efficient and quick a way as at least I've gotten comfortable using in paper. So let me leave those with my comments. I know Rishab and Shwetha are going to comment on this as well. So let me then yield the screen, not the floor, yield the screen to Rishab or Shwetha.
Thanks, Steve. Shwetha, you're okay if I go now? Yeah? Yeah, absolutely. Cool. So I know time is very short, so I'm just going to make 3 very quick remarks coming out of what Stephen was talking about. First, in terms of use of technology at the hearings, keeping aside the point that Stephen was making about how e-documents may still not be, or e-bundles may still not be a complete replacement for the physical bundle, especially for counsel. And I totally agree with that. Where I act as counsel, I still use physical bundles. Even if it's not a physical bundle for the entire set, at least a physical bundle for my crosses and openings and stuff like that. But the point that I wanted to briefly make is that, and this would jive better with sort of the Indian audience that may be on this, is that there is still a world of difference between how we use technology in our international foreign-seated institutional arbitrations versus how we use it for our India-seated arbitrations, especially the ad hoc ones. And while Zoom platform is common across both, and that's driven by necessity really, the use of live transcription, the use of hyperlinked bundles, the use of electronic presentation of evidence, those things which are increasingly becoming very common among foreign-seated institutional arbitrations are still not that common amongst India-seated arbitrations. And that's largely because of the preference of the arbitrators and less to do with the availability of the relevant technology. So I do hope that with these technologies becoming more prevalent and with platforms like Terrace coming up, there is a greater adoption of those practices, even in domestic arbitrations, because there's nothing to doubt the fact that they make the entire process far more efficient and cheaper. That's the first remark. The second, Stephen mentioned arbitrator intelligence. I mean, that's something which is very close to my own heart. It's an area that I have researched quite a bit on. I wrote a few articles about influence of arbitrators and made a database about how, what kind of feedback might be available about arbitrators. I really think that's an area where ultimately some sort of technological innovation, along with people's willingness to accept that this is ultimately just a service, that arbitrators are providing just a service, and we should be willing to give reviews about them. We should be willing to be open about them, and we should be willing to accept that word of mouth is not good enough. And if an arbitrator is a bad arbitrator, write about it, talk about it. And if it's a good arbitrator, talk about it. But I think ultimately a move away from treating arbitrators like judges, where you don't speak very openly about it, and there are concerns about contempt and all of that in India in particular, to treating arbitrators like pure service providers and giving reviews and talking about it openly, I think would serve the community really well. So both technology as well as some change in how we behave as counsels as well would help. That's my second point. And the third point, just very briefly, and it sort of goes back to my first point as well about adoption of technology generally. I've heard from different people, different views about whether ultimately it's a good thing or a bad thing from the standpoint of growth of practice. And this is more at an individual level. I think without doubt, adoption of technology is helpful for everyone. Of course, it's great for clients. It makes the process cheaper. It makes it faster. I think it's excellent for lawyers as well as counsel. We, in the last 2 years, have done more hearings than we've ever done before, simply because while sitting in Mumbai, we can appear anywhere in the world. And that's true, I think, for any counsel anywhere in any jurisdiction. And therefore, simply because we have these technological innovations available now, clients, I believe, for the first time are able to actually use lawyers that they genuinely want to use, rather than having to simply rely upon local lawyers or to have their lawyers fly down to jurisdictions when that may not even be necessary. And I think we should all endorse that a lot. And I personally fear that when we are back to the physical world of doing hearings, some of these lessons that we've learned and some of these best practices that we've adopted, we may lose them. But I hope that doesn't happen. And equally, I think these technological innovations are great from an arbitrator's perspective as well, because many arbitrators now can accept appointments which they would have otherwise not accepted because they were either not available to travel to those places where the hearing venue might be, or they would be just so busy that they couldn't fit that in their schedules. So overall, I hope that these innovations that we're talking about get adopted and stay with us going forward as well. And I hope in particular that in the Indian context, they get adopted much more than that has been the case in the past couple of years. That's it. Shwetha, you should jump in now.
Thanks, Rishab. Thanks, Stephen. And I think before I jump on to add anything, I thought the conference could have been done in a metaverse, maybe. So we were, of course, more topical in terms of discussing, and which is, of course, on the fun side, how things would have been different. But moving on, to share my 2 bits, and I was just thinking when Rishab was sharing his experience, that when, the first arbitration that I was a part of, and which is when I was an intern in 2006, versus an international arbitration that I did in 2011, and how things were within those 4 or 5 years so different, from carrying actual physical files, and they used to be bags in a domestic, and it was a high value case, and you would be carrying those bags around for the arbitration that had to be done. And everything was on paper. There was no question of things being hyperlinked. There's no question of e-bundles, and how things have dramatically changed in terms of how these things are managed. And of course, it has hugely impacted the efficiency in arbitration. So if I could just maybe summarize in certain context of what is the current adoption that, and this is without reference to the pandemic, some of these have been there pre-pandemic, and I think maybe more focused post-pandemic, during this time. And maybe share some bits on how the future innovations in technology could maybe replicate certain aspects of institutional case management. How the things that we are doing at SIAC, maybe things could be different in some years henceforth if we are able to integrate technology better into the system. So of course, when I talk about the current adoption, some of these things everyone may be familiar with, but let me just enlist them anyway. Of course, we see a lot of e-filings, and that in a way is where we say moving away from paper filings and the actual big bunch of documents in paper to now things being done electronically. Virtual hearings, of course, everyone's been talking and mentioned about. You see now the case repository being done in digital. And an important aspect, again, is of document sharing, which is done on now the whole cloud system. And there are shared links, which are the secured shared links that parties use to be able to share the documents. E-bundling, and this is very interesting because otherwise, like I said, if I go back to 2006 and compare how you would normally have 4 paralegals working all night to prepare the documents and the bundles, but this can now, e-bundles can be done pretty much in a click when you have all the contemporaneous proceedings, to be able to put together all the documents that have been filed so far. And one tool that I have personally really enjoyed in technology is the hyperlinking, because it used to be so confusing to maneuver around the set of documents. And I think we might be overusing the word documents, but that's really, I think the most difficult part with the arbitrations, and especially the complex and higher value arbitrations. You see so many documents and so much data that one has to manage. And that itself is a skill. So I think the lawyering bit is on one side, and to be able to manage the document data is really, a skill set in itself. But technology has made that so much more easier. While Stephen mentioned there's still more to be done, but I think we have come a long way in terms of being able to handle documents, to be able to review them, segregate them category wise, and this is a very, very important tool. We of course have been seeing transcriptions, and that again is a huge value add to the arbitration proceedings itself on a real-time basis, and of course we will have a debate later where we some comparison drawn from the stenographers typing versus a real-time transcription, how things would be different with that. I think that also technology has allowed to inbuild more security into the system, with your access level controls, and I think somewhere you have multi-factor authentications, etc. So which is a huge concern, in arbitrations. You want to be careful of your data, privacy and the protection of the data. I think technology is able to, handle or maybe deal with some of these issues that we've been seeing in arbitration. On another thought of, what could be different, and I think this is more futuristically, and I don't know how realistically can I say how many years would it take for these things to change, but maybe it can replicate a large chunk of work that is done at the institutional level. Starting with, the institutions, of course, are tasked with looking at the timelines and managing that things are sort of progressing in the way that the rules require them to. There can be some software which can send out automatic notifications on the next step or the timeline in the proceedings. So, once the date hits, you get a set reminder on your system, and this is the next filing that needs to be done. So, you can have these inputs put into a program, so maybe, this aspect could also get replicated. Another important is, of course, that when the notice of arbitrations are received by the institution, we check that if it's in compliance, if there is a substantial compliance of the requirement of the rule. If we can, potentially have an automated inputs from the arbitration clauses considered in previous cases into a software which could be programmed to recognize that these are valid arbitration clauses on a prima facie basis, and this compliance has been done. So I think that review of a notice of arbitration at the first year level before it comes to us, in terms of the human interaction, I think would also be useful. Another, and this is slightly different from the arbitrator intelligence. This is if we can have algorithms which can assist in appointment of arbitrators. So when on a case when we have to appoint an arbitrator, usually it's really the human intelligence that we rely on, when we look at, okay, what is the choice of law, the governing law involved, what is the, the considerations in terms of the dispute, etc. When we look to appoint an arbitrator, if we can put in data and inputs into the software to be able to filter and come out with names, taking into account all of these aspects of governing law, the contract, the nationality of the parties, the subject matter, some in dispute, etc. So, there is a, so this software, would ideally in a few seconds would throw up names, whereas, a counsel at SIAC would take significantly more time in running through this exercise and at their discretion to perform the same task. And another important element could be where if you have electronic document management system, and this would help. Of course, I know that some institutions have introduced that in their in their operations, and this could help in the scrutiny of awards. So you can compare in terms of whether all pleadings have been set out correctly, your grammar check, your spell checks, your the specialist terms, to ensure that the award has covered all the issues that had been raised by the parties, and who knows, maybe to even cross check against Article 5 of the New York Convention. So, I think there's so much more that can be done. And I think I'm least qualified to talk about technology. I'm 2 steps behind Stephen. I still have my hard books when I have to read through. So Kindle is really the last option when there's no light in the room because my baby is crying. Otherwise, I still resort to hard books. But when I look at the prospect of what can be done and so much more that I need to learn and understand and adapt to make things faster and not waste that much time. And I think, there is still a long way to go. But congratulations to Vikas to put this platform together, where we are discussing and talking, and hopefully more and more parties are able to utilize this, to overcome sort of the concerns of how slow the process is and how tedious the tasks are, which would otherwise be simplified with technology. And like I began with, maybe have metaverse for the conference. I think, it could be a fun topic to discuss. How would arbitration proceedings maybe in metaverse, in 20 years henceforth, and who knows, maybe 10 years henceforth. So these are the two bits that I wanted to add. Stephen, anything, or Rishab, if you wanted to add, please feel free to.
Just very quickly, there's actually a question that we have in the Q&A. I thought it was quite an interesting question to just touch on and see what people thought about it. The question was, can draft arbitral awards be drafted by using modern tools of modern technology and artificial intelligence and be edited by the arbitral tribunal arbitrator? My own view is I don't think we're there yet. I think it's quite a way where we'll get there, but I think it's a real possibility as artificial intelligence continues to develop. We've already seen in different aspects how artificial intelligence has grown in leaps and bounds. We see that in the world of chess, that a computer using artificial intelligence can now beat the best chess players in the world. And there are many other applications of artificial intelligence. I was reading in a book on Kindle, which talked about how in medical sciences as well, they're using artificial intelligence to develop new vaccines and other things, which just wouldn't have been possible because the human mind cannot crunch as much information as a computer can. So I don't doubt that in future this will encroach upon the world of judging and arbitrators and the law. But I think we are quite a long ways away from that. I don't know whether Rishab or Shwetha has a view on this.
No, I agree, Steve, but I do think that in the same way as Shwetha, you were saying quite interestingly that perhaps the substantial compliance test that you perform at an institutional level for the incoming notice of arbitrations could be done by a computer, by technology. Why couldn't the first few sections of the arbitration award, Stephen, the ones which simply repeat the basic stuff, right? Who the parties are, what the arbitration agreement is, the seat is, etc. And if I may to go a step further, the second part of it, which just reiterates what the issues were and what both sides' arguments were, where actually there's very little application of mind. There's of course a need to ensure that that's put in a proper way. But I don't know if technology is that advanced, but if it is, I suspect those portions could be drafted through use of technology. And then, of course, you come to the tribunal's findings and the award itself, which, to the best of my knowledge, still needs human input. I hope that remains the case for some time, because then most of us would also become redundant. But I suspect certain portions of the award perhaps can be written through technology.
I agree. And I think in certain way, it will help, even from the institution point when we're looking at the scrutiny. Some of this task would be taken care of, and I think there'll be lesser errors if, for example, the name of the parties, the procedural history, the issues being raised, all of that is automatically being put together in a draft award, and then the substantive decision process is done by the arbitrators, which I find difficult would ever get replaced